Good day, everyone. I'm Criselda Gregorio, third year from BSBA major in Marketing Management. I would like to greet also our prof, Mama Jean Bindisha Ramo. So let's start. Our topic for today is all about law of obligations and contracts. And law of obligation and contracts, we are going to tackle about extinguishment of obligation, general provisions, payment, or performance according to Article 1232 to Article 1252. Here is our topic outline. So we have fulfillment of payment. So nakapaloob siya sa Article 1232 to 1233. Then letter B, we have payment by third-party debtor. Nakapaloob naman siya sa Article 1236 to 1238. Then letter C, we have validity of payments. Nakapaloob siya sa Article 1239 to 1243. Kailan ba natin masasabi na valid yung payments or invalid yung payments? Then letter D, we have modes of payment. Nakapaloob naman siya sa Article 1244 to 1250. And general rules, so yung mga exceptions. So the partial payments, payment of debts in money, payment of debts in other forms. And then, the last one is the venue of payment. So, nakapaloob naman siya sa Article 1251. So, let's begin. Fulfillment of payment. In ordinary parlance, payments refers only to the delivery of money as a mode of extinguishing an obligation. It has a much wider meaning. So, yung payment daw ay naka-refer lang siya doon sa pera or sa delivery ng pera as a mode of extinguishing an obligation para ma-extinguish yung obligation. But payment may consist not only in delivery of money but also the giving of a thing other than money. So, pwede pala na yung payment, may tuturing din siya na hindi lang pera, pag-deliver ng pera, kundi ito ay pagbibigay din ng bagay na other than money. So, the doing of an act or not doing of an act. When a debtor pays damages or penalty in lieu of the fulfillment of obligation, so nakapaloob ito sa Article 1226, there is also payment in the case used in Article 1232. So in Article 1232, payment means not only the delivery of money but also the performance in any other manner of obligation. Yun ang sinasabi kay na hindi lang, kapag sinabing payment, hindi lang siya ibig sabihin na pera, kundi nakapaloob din doon, pwede siya maging performance or in other manner ng obligation, no, para mapunuan yung obligasyon or mabayaran yung obligasyon. In law, sabi dito, payment and performance are synonymous. So, para magkahalintulad sila, may pagkakapareho sila. Next, we have elements of payment. So, ito yung mga elements ng payments. Meron tayong 7. Under the common law doctrine at the same traditional influence, the elements of payments are analyzed in two. So, pwede pala itong pambayad, no? So, persons who may pay and to whom payment may be made. So, person who may pay and whom payment to be made. So, kung sino yung magbabayad at kung sino yung babayaran niya. So, thing or object in which payment must consist. So, pwedeng bagay, sasabi nga kayo na hindi lang pera, pwedeng bagay or object, thing na kung saan naglalaman din siya ng pambayad or ng payment. So, the cost thereof. So, nandoon din yung halaga, no? And then, number 4, the mood or form thereof. So, nandun din yung mood or yung form na sinasabi natin. And then yung place. So, the place and the time in which it must be made. So, dapat importante din kung saan sila, kung ano yung napagkasunduan na oras, na lugar, so kung saan, importante din yon. So, next one, number 6 is the imputation of expenses occasioned by it. So, yung responsibility, no? Responsibility ng expense or occasion. So, number 7, we have the special parts which may modify the same in the effects they generally produce. So, magkapareho yung halaga no? Halimbawa, ano man yung bagay na yun or object na yun, pareho siya, yung halaga niya, pareho kung ikukumpara sa pera. Next slide tayo. We have a burden of proving payments. Burden of proof is the duty of a party to present evidence of the facts and issue necessary to prove the truth of his claim or defense by the amount of evidence required by the law. So, dapat nandoon yung responsibilidad na dapat kapareho yung ipipresent na ebidensya or evidence, pareho yung kinakailangan na proof na dapat ay magkahalaga or magkahalintulad, magkasing halaga yung amount, no, according doon sa required ng law, ng batas. So, dapat pareho yung halaga kung bagay man yan or object man yan, dapat pareho yung halaga at meron kang proof, no, kailangan yung proof na proof or truth of his claim or defense, so by the amount. So, that pareho yung halaga kapag tinanggap yun, no, tinanggap yun ni creditor. So, next, when the existence of the debtor, so yan, when the existence of the debtor who pleads payment or offers such as a defense to claim of the creditor rather than on the later to the proof non-payment. The debtor has the burden of showing with legal certainty that the obligation has been discharged by payment. So, kapag mayroong proof na pareho yung halaga na ng bagay na yon or ng object na yon na ipapambayad kay creditor, so, yung obligation ay magiging or madidischarge na yung obligation. Ibig sabihin, nakapagbayad na. So, may payment na nangyari. Only when the debtor introduces evidence that the obligation has been extinguished does the burden shift to the creditor. So, yun nga, sinasabi, kapag mayroong proof, itong sa debtor or meron siya inintroduce na proof, no, na proof na mayroon nga, no, na merong katumbas na halaga, yun na papambayad niya dun sa obligasyon, no, it has been extinguished. So, does the burden shift to the creditor. So, yun na. So, pwedeng yung meron na siyang evidence na makikita ni creditor na kasing halaga nga or katumbas nga na ipapambayad niya doon kay creditor. Next, we have payments or performance. So, ito yung sinasabi natin, payments or performance. We have 6. So, who can pay? Sino ang magbabayad? Number 1. And number 2, who to pay? Sino ang babayaran? Number 3 is what to pay. Ano ba yung ipapambayad niya? And then number 4, how to pay. Paano niya ba babayaran yon? And number 5, where to pay. Saan ba? Saan niya ba babayaran yon? And number 6, kailan, no? Where to pay, saan, kailan, no? When to pay, kung kailan. Where to pay, saan, and then when to pay, kung kailan. Tama. So, we have next slide. How to pay. Paano ba? So, paano magbabayad? When debt considered paid. So, kailan ba may considered na paid na itong si debtor? According to Article 1233, debtor shall not be understood to have been paid unless the thing or service in which obligation consists has been completely delivered or rendered as the case may be. So, masasabi lang na na-considered na bayad na itong sa debtor kapag naisagawa niya na yung obligasyon at nakompleto niya, na-deliver niya na or na-render niya na yung service or yung obligation. And that may refer to an obligation to deliver money, to deliver a thing other than money, to do an act, or not to do an act. So, pwede yun. So, kapag ang obligasyon, so nag-deliver siya ng pera, pwedeng bagay or object. Kapalit doon ng pera, pero may katumbas siya na halaga. Next, integrity of the prestation. The requisite means that the prestation be fulfilled completely. So, ibig sabihin na fulfilled na yung responsibility or yung obligation na yun. Next tayo. So, a debt to deliver a thing, including money, or to render service is not understood to have been paid unless the thing or service has been completely delivered or rendered as the case maybe. So, ito yung sinasabi natin kaya kapag nakompleto na, na-render na yung service, or completed delivered na siya, may sasabi natin na yung case ay okay na, na-fulfilled na yun, bayad na. Partial or irregular performance will not produce the extinguishment of an obligation as a general rule. So, nakapaloob daw sa general rule na ang partial or irregular performance ay hindi siya nagpo-produce or hindi siya masasabing fulfillment na yon. Hindi siya ma-extinguish na fulfillment kapag partial lang yung binigay mo or irregular lang yung performance na ginawa mo. Hindi mo na fulfilled, no? Hindi siya completely delivered and hindi mo rin na-rendered yung service na yon or yung obligation na yon. According to Article 1234, if the obligation has been substantially performed in good faith, the obligator may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. So kapag yung obligation according sa 1234, kapag yung obligation ay na-perform na ng isang taong mapagkakatiwalaan mo, so the obligator may recover though there had been an strict and complete fulfillment. So si obligator makakahinga na siya ng maluwag kasi nga tapos na yung obligasyon niya, nakakompleto niya, na-fulfill niya na yung obligasyon niya, kaya less damages suffered by the obligee. So, kahit saan naman, kapag binigyan tayo ng obligasyon, ng responsibilidad sa school, sa trabaho, at kung saan-saan pa, kapag natapos natin yung mga responsibilidad natin, yung mga gawain natin, syempre, nakakahinga tayo ng maluwag, no? Magaan sa pakiramdam, masarap sa pakiramdam na natapos mo na or nagawa mo na yung mga responsibilidad na nakaatang sa balikat mo, hindi na ganun kabigat yung responsibilidad kapag na-fulfill mo na or na-kompleto mo na yung responsibility or yung obligation mo. So, yun. Next tayo. Recovery allowed in case of substantial performance in good faith. So, dun sa mapagkakatiwalaan. In Article 1234, is the first exception to the rule laid down in Article 1233. The reason for the exception given by the Code Commission is as follows. So the above rule, ito yung sinasabi, yung Article 1234 is adopted from American law. Its fairness is evident. In case of substantial performance, the obligee is benefited. So the obligor should be allowed to recover as if there had been a strict and complete fulfillment, less damages suffered by the obligee. And this last condition afford a just compensation for the relative branch committed by the obligor. So, yun nga sinasabi dito, no? Yung performance na kung saan ay magbe-benefit si obligee, no? Magiging magaan na yung kanyang pakiramdam kapag naisakatuparan na yon, and then inallow ni so si obligor should be allowed to recover as if there had been a strict and complete fulfillment, less damages suffered by the obligee. So yung sinasabi nga natin kanina, mas makakahinga na ng maluwag kapag na-complete na or nagkaroon na ng fulfillment doon sa obligasyon. Next tayo. So we have requisites for the application of Article 1234. Tama ba? So requisite of application. So the requisites are, so we have number 1, there must be substantial performance. Its existence depends upon the circumstances of each particular case. So yung performance nakadepende doon sa circumstances or sa particular case. The obligor must have been in good faith. So, dapat mapagkakatiwalaan si obligor. So, good faith is presumed in the absence of proof to the contrary. So, kapag mapagkakatiwalaan and meron siyang proof, so pwede yung pamalit, kumbaga, no? Pwedeng gamitin. In Article 1235, the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection. The obligation is deemed fully complied with. So, pwede palang tanggapin according sa 1235, pwede tanggapin ni obligee yung performance na kung saan kaya niyang knowing its completeness and irregularity. So, kaya niyang gawin yung responsibility na yun or yung obligasyon na yun na nang walang pag-aalinlangan or protest or objection na mai-comply yung nasabing obligasyon. So, how to pay? Substantial performance in good faith according to Article 1234. So, yun yung sasabi natin kanina. In general rule, payment must be complete according to Article 1233. Dapat ay kompleto yung bayad. Para masabi mong fulfillment na or fulfill na yung payment. Tapos, the creditor or debtor cannot be compelled to accept or make partial payment. Article 1248. So, yan ang nakapapaloob doon, si creditor or debtor. So, hindi pwede yung partial payment. No? Hindi pwede yung partial payment lang. Compelled to accept or make partial payment. Dapat kompleto yung bayad. Hindi pwedeng partial lang. So, meron mga exceptions. So, creditor waives complete performance according to Article 1235. So, pwedeng performance naman siya. And contrary stipulation, no? Kabaliktaran and partially liquidated, no? Sa tawag doon ay na-liquidate na or kumbaga meron ng mga exceptions na sinasabi. So, ito yung mga exceptions na yung creditor waives complete performance and then contrary stipulation and then partly liquidated. So, meron proof. Next. So, letter B, we have payment by the third-party debtor who can pay. According to Article 1236, the creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of obligation. So, hindi pala pwedeng tumanggap si creditor ng payment or ng anong performance galing kay third person kapag hindi interesado si third person na ma-fulfill yung nasabing obligasyon. Unless there is a stipulation to the contrary. So, maliban na lang kung mayroong responsibilidad si third person doon sa nasabing obligasyon. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor. So, kapag si debtor ay nagdemand ng payment pero hindi alam ito ng walang knowledge, no, except that if he paid without the knowledge and without the knowledge or against the will of the debtor. So walang alam, hindi pala alam ni debtor. So walang alam si debtor doon sa binayad ng ni debtor na isa. So or ng third person. So hindi alam walang alam si debtor. So hindi niya alam at against doon sa will niya. He can recover only insofar as the payment has been beneficial to the debtor. So pwede niya i-recover yun kapag merong kahalagahan doon kay debtor, no? And then in Article 1238, sabi dito, payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be donation. So kapag ang payment na dapat yung binayad ni third person doon kay creditor ay hindi naman does not intend to be reimbursed, hindi naman interesado si debtor na bayaran yon, no, magiging donation na lang yon, which requires the debtor's consent. So kinakailangan kasi ng consent ng debtor. Then by the payment is in any case valid as the creditor who has accepted it. Magiging valid yung payment, no? Pero sabi doon, magiging valid yung payment kapag si creditor tinanggap niya itong binayad sa kanya third person. So, yun, magiging valid yung payment. Then, next natin, generally, the following can do the payment. Sino ba dapat, no? We have three, the debtor, the authorized person, And then successor in interest, yun yung sinasabi ko. Authorized siya, may responsibility siya doon sa obligasyon, and then successor in interest. So yung tagapagmana, no? Or yung napagbilinan. Then the payment of these persons are valid. So yung kapag debtor ka, authorized person ka, successor ka in interest, so yung payment mo ay maging valid siya. Their payment should be accepted by the creditor. So yung payment nila ay tatanggapin ni creditor. Ito ang tawag natin na fulfillment of payment. So sila lang yung mga magsasagawa. Sila may karapatang magsagawa ng magbabayad, no? Then payment of a third person. Payment by a third person who does not intend to be reimbursed. So, yung payment na third person ay hindi siya intend na palitan, no? Reimbursed. Yung mapalitan yung payment na kanyang isinagawa. So, according to Article 1238, embodies the idea that no one should be compelled to accept the generosity of one another. So, yun. If the paying third person does not intend to be reimbursed, the payment is deemed a donation. So, maging donation na lang yung kanyang payment, which requires the debtor's consent to be valid. So, kailangan ng consent ng debtor para maging valid yung kanyang payment. Yun ang nakalagay sa Article 725. However, if the creditor accepts the payment, it shall be valid as to him and the payer, although the debtor did not give his consent to that donation. So, magiging valid siya kapag tinanggap yung payment. Who are interested persons? So, sino-sino ba yung mga interested persons na sinasabi dito? So, merong guarantors, si sureties, si preferred creditors, and owners of securities. Next. So, ito yung key summary, sinasabi natin kanina. So, interested in the fulfillment of obligation. Yan, nakasama rin na siya. There will be valid payment, and so masasabi lang natin na valid yung payment kapag the creditor cannot refuse payment. Hindi niya ma-refuse yung payment, hindi niya matanggihan. The debtor shall fully reimburse third person. So, kapag si debtor ay nabayaran niya yung fully reimbursed. So, pinalitan niya. So, napalitan niya itong si third person. Or binayaran niya si third person, no? Fully reimbursed. Pinalitan. Binayaran, pinalitan. Yun. So, the third person is the subrogated to the rights of the creditor. Then, we have the not interested in the fulfillment of the obligations. Yun naman hindi interested dun sa fulfillment ng obligation. The creditor can refuse payment. Pwedeng tanggihan ni creditor yung payment. Kasi nga, hindi sila interested sa obligasyon na ma-fulfill yung obligation. Next, if creditor consent to payment, so the creditor shall fully reimburse third person. So kapag merong consent, no, si debtor ay pwede niyang palitan yung payment doon kay third person. And then third person is subrogated to the rights of the creditor. Then, if the debtor does not consent to payment according to Article 1237, the debtor shall reimburse third person for what he has been beneficial to him. Kung ano yung kapakipakinabang sa kanya, so pwedeng i-reimburse ni debtor yun, si third person. Pwede yung bayaran. And then, the third person is not subrogated to the right of creditor. And then, we have the does not intend to be reimbursed. So, hindi niya intensyon na palitan or bayaran. No? Ito naman sinasabi dito. The creditor can refuse payment. Pwede niya rin tanggihan yung bayad. And then, if the debtor consent to payment, it is deemed to be a donation. So, kapag yun naman, pwedeng maging donation na lang yung nasabing payment. So, if debtor does not consent to payment, so kapag hindi naman, wala namang consent si debtor doon sa bayad, the debtor shall reimburse third person for what he has been beneficial to him. So, pwede niyang palitan kung anong beneficial din doon kay third person. Then, the third person is not subrogated to the rights. No? Yun na nga. So, that's the key summary. Next, we have a validity of payments. Whom to pay? According to 1240, Article 1240, payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. So, yun ang sinasabi natin kanina. Kung sino ba dapat yung binabayaran. So, yung favor doon sa obligasyon na may sagawa yan, obligation has been constituted, or his successor in interest, or yung person na authorized na mag-receive ng payment. Next, person to whom payment shall be made. Payment shall be made to the creditor or obligee person in whose favor the obligation has been constituted. So, kung sino yung nga, kung kanya isasagawa yung payment. So, doon sa creditor or obliged, no, na maisagawa yung, or pabor doon na maisagawa yung obligasyon na yun. Then, his successor or in interest. So, yun ang sinasabi natin. Like an heir or assignee. Kung sino yung inassign niya, kung sino yung may responsibilities doon, no? Or tagapagmana, sabihin natin. And then, the letter C is any person authorized to receive it. Kung sino yung inauthorize niya na mag-receive ng nasabing payment. So, number 2, the creditor referred to must be the creditor in the time the payment is to be made, not at the constitution of the obligation. Hence, if a person is subrogated to the right of the creditor, payment should be made to the new creditor. Ayan. So, number 3, we have, when payment is made to the wrong party, the obligation is not extinguished as to the creditor who is without fault or negligence, even if the debtor acted in utmost good faith and by mistake as the person of the creditor, or through error introduced by fraud or the third person. So, yung payment, no, na sinasabi dito ay pwedeng maging yung mapagkakatiwalaan, no, pwedeng siya yung magsagawa ng payment, no? So, next tayo. Meaning of any person authorized to receive it. So, in Article 1240, the phrase means not only a person authorized by the creditor, but also a person authorized by law to receive it. So hindi lang pala yung authorized ni creditor yung po pwedeng mag-receive ng payment, kundi authorized din ng law. Then, authorized ng law. Or such as guardian, executor, no? So, yung mga inauthorized ng law, so yung guardian, executor, or administrator of the estate of the deceased and assigned or liquidator of a partnership or corporation, as well as any other person who may be authorized to do so by the law. So, hindi lang pala yung inauthorized ni creditor yung pwedeng tumanggap ng payment, kundi pwedeng si guardian, si executor, administrator of the state, or of a deceased, no, pwede yun. And then yung assigned or liquidator of a partnership or sa corporation man yan, or other person who may be authorized to do so by the law. Then, effect of payment to an incapacitated person. According to Article 1241, payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. So, pwede pala yun kapag beneficial sa kanya yung nasabing bayad, no? Payment made to the third person shall also be valid insofar as it has redounded to the benefit of the creditor. So, pwede pala na kapag yung payment, ginawang payment ni third person ay valid kapag ito ay mayroong benefit doon kay creditor. Such benefit to the creditor need not to prove in the following case. Ano kaya yun? So we have number 1, if after the payment, the third person acquires the creditor's rights. So kapag meron pala, no, merong proof na ginawa itong kapag nagbayad na si third person tapos meron siyang ginawang proof na nagpapatunay na natanggap nga ni creditors itong kanyang binayad. If the creditor ratifies the payment of the third person. So kapag ni-ratify ni creditor yung payment ng third person. Number 3, if by the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment. So, yun. Kapag merong authority si third person na mag-receive ng payment. No? In the absence of his benefit, the debtor may be made to pay again by the creditor's guardian. So, kapag walang kahalagahan, no? Walang kahalagahan. So, si debtor ay pwede siyang magbayad ulit kay creditors, no? Or yan, pwede si debtor pwede siyang magbayad ulit, no? And or by the incapacitated person himself when he acquires or recovers his capacity. Proof of such benefit is incumbent upon the debtor who paid. So, yun. Kapag meron ng bayad. Effect of payment to a third person. Payment to a third person or wrong party is not valid except, hindi daw siya valid, no? Yung payment ni third person or wrong party is not valid except insofar as it has redounded to the benefit of the creditor. Maliban lang daw kung merong kahalagahan ito kay creditor. It is immaterial that the debtor acted in utmost good faith and by mistake as the persons of the creditor. Or though error induced by fraud of a third person of the creditor is without fault or negligence. Then, the creditor was benefited by the payment made by the debtor to a third person is not presumed and must, therefore, be satisfactorily established by the persons interested in proving this fact. In the absence of such proof, the payment thereof in error and a good faith will not deprive the creditor of his right to demand the payment. So, kapag walang proof, pwede palang mag-demand ng payment ulit si creditor, no? Kasi wala namang pala na pwede mong sinungaling or whatever na kasi walang proof na nabayaran na itong pwede pa siyang walang proof na nabayaran na kaya pwede pa siyang mag-demand ulit ng payment, no? Ito yung magiging effect kay third person kapag walang proof. Next tayo. When benefit to creditor need not to be proved by the debtor. So, the debtor is relieved from proving benefit to the creditor in case of subrogation of the payment in the creditor's right, ratification by the creditor, or stoppel on the part of the creditor. So, yun pala yung mag-benefit si creditor. So, kapag hindi na-prove ni debtor yun. Yun yung mga benefit ni creditor kapag hindi na-proof ni debtor. So, dapat ma-proof ni debtor yung mga kanyang binayad or dapat ma-proof niya na isagawa niya na yung kanyang obligasyon na magbayad. Letter D, modes of payment. What is to be paid? Ano ba dapat yung babayaran? The delivery of promissory notes payable to order or bills of exchange or other mercantile in Article 1244. So, nakapaloob siya sa 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than which is due. So, in obligations to do or not to do, an act of forbearance cannot be substituted by another act or forbearance against the obliger's will. So, hindi pala pwede, no? Hindi pala pwedeng palitan. Yung an act of forbearance, it cannot be substituted by another act of forbearance against the obliger's will. So, hindi pala pwede. Next, very prestation due must be complied with. Number 1, we have the first paragraph refers to the real obligation to deliver a specific thing, a thing different from that you cannot be offered or demanded against the will of the creditor or debtor as the case may be. Then the second one is the second paragraph refers to personal positive and negative obligations, the act to be performed or the act prohibited cannot be substituted against the obliger's will. So yung sinasabi kayo na according to 1167, Article 1167. So, when prestation may be substituted, kailan daw ba? Of course, substitution can be made if the obligor consents. So, kapag merong consent, no? In facultative obligations, the debtor is given the right to render another prestation in substitution. So, kapag merong consent, pwede pa lang magsagawa ulit in substitution doon sa obligasyon, no? Yan ay nakapaloob sa Article 1206. According to Article 1244, will not also apply in case of waiver by the creditor or substitution is allowed by stipulation with consent of the creditor. So, yan. According naman sa Article 1249, no, the payment of debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. Documents shall produce the effect of payment only when they have been cashed or when through the fault of the creditor they have been impaired. So, yan. Kapag nakapag-produce na ng payment. And then, in the meantime, the action derived from the original obligation shall be held in abeyance. So, 1170, Article 1170. So, what is to be paid? Ito dapat yung mga binabayaran to give a specific thing. So, dapat kapag magbibigay ka ng specific thing, debtor cannot compel C to receive a different specific thing even later than same value or more valuable than that due. So, yan ang nakapaloob sa Article 1244. So, what is to be paid? To give a generic thing. Creditor cannot demand a thing superior quality. So, hindi siya pwedeng mag-demand kay debtor, no, ng mas mataas doon sa itinakda na dapat ay binabayaran niya. Debtor cannot deliver a thing inferior quality. So, hindi rin pwede si debtor. Unless, so maliban lang, kapag quality and circumstances shall be taken into consideration. So, nakapaloob yan sa Article 1246. Maliban lang kapag may mga circumstances na nangyari and pwede siyang may consider na pamalit doon sa pambayad. So, obligation to do or not to do. In obligations to do or not to do, an act or forbearance cannot be substituted by another act of forbearance against the obliger's will. So, yan naman nakapaloob sa Article 1244. Then, the last one, we have obligation to give money. The payments of debts in money shall be stated made in the currency stipulated, and if it is not possible to deliver such currency, then the currency which legal tender in the Philippines. So, yan naman ang nakapaloob sa Article 1249. Next, we have the last one, venue of payment. Where to pay? Saan nga ba dapat tayo nagbabayad, no? Or saan sila dapat magbayad? So, yung place, no? Article 1251, payment shall be made in the place designated in the obligation. Kung saan yung napag-usapan nila na magbabayad sila. Halimbawa, may napagkasunduan sila na lugar, oras at panahon. Kung kailan yun, dapat doon isasagawa yung nasabing pagbabayad. There being no express stipulation, and if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. So, pwede yun kapag napag-usapan na ng maayos kung saan dapat i-deliver, no? Yung yung nasabing bayad. So, yung itinakda, no? Kapag dapat ay kapag nag-set sila ng time kung saan time, oras, panahon, kung ano yung napag-usapan nila. So, dapat yung itinakdang oras at panahon na yun, may isagawa yun ayon sa obligasyon na dapat magbayad. So, kapag nangako ka sa isang tao na dapat ganito, magbabayad ka sa ganitong oras at panahon, dapat ay tinutupad mo yon sa tinakdang oras at panahon na napag-usapan ninyo. In any other case, the place of payment shall be domicile of the debtor if the debtor changes his domicile in bad faith or after he has incurred in delay. The additional expenses shall be borne by him. So, kapag na-delay ka ng bayad mo, pwede palang magdagdag, no? Parang katulad din sa mga patubo or ano, pwede palang mag-demand ng payment ulit or magkakaroon ulit ng panibago kang babayaran, no? Tutubo ulit siya. So, these provisions are without prejudice to venue under the rules of the court. So, wala pala, no? Next tayo, place where obligation shall be paid. Saan? According to Article 1251, gives the rules regarding the place for the payment of an obligation without prejudice to venue under the rules of court. Number 1, if there is a stipulation, no, merong itinakdang oras at panahon, lugar kung saan yun, the payment shall be made in the place designated. So, dapat ay may sasagawa yung nasabing pagbabayad ayon doon sa nakasunduan ng oras at panahon at yung lugar. If there is no stipulation and the thing to be delivered is specific. So kapag wala naman, okay lang naman siguro. Kapag walang napagkasunduan ng oras at panahon and then yung lugar, no, the payment shall be made at the place where the thing was. So pwedeng doon sa lugar kung saan nagkita. For example, biglang kita lang, ay naalala ko may utang pala ako sa kailangan ko magbayad. O may kailangan pala ako ibigay sa'yo, may na-promise pala ako sa'yo na bagay na dapat ko ibigay sa'yo. Kung kahit saan na lang sila magkita, pwedeng gawin yung pagbabayad na yun or sagawa yung pagbabayad. Kapag walang stipulation, kapag wala silang napag-usapan, itinakda. Walang contract or sabihin natin na wala nga silang agreement, no? Pwede yun. According yan sa yun sa part ng video natin dun sa Law of Obligation and Contracts. Then, number 3, if there is no stipulation in the thing to be delivered is generic, the place of payment shall be domicile of the debtor. So, yun sa part 3. In this case, the creditor bears the experiences in going to the debtor's place to accept payment. So, pwede niyang puntahan, no? Pupuntahan niya na lang sa debtors kung saan ay tatanggapin niya yung bayad. So, pwede niyang puntahan. According yan sa Article 1247. Next, when to pay? Kailan ba? So, upon demand. Kung kailan yun nga sabi, itinakda. So, kailan siya dapat magbayad? So, upon demand, kapag sinabi niyang magbabayad sa ganito or dapat bayaran mo, dapat isagawa mo yan. When obligation is due and demandable, but debtor may pay before due date if period is for benefit of debtor. So, upon demand, pero pwede naman na obligasyon ay isagawa, no? Due and demandable. Kapag dinemand ni debtor na, oy magbayad ka na, ganito, ganyan. So, kailangan nang isagawa yung ni debtor yung pagbabayad bago pa yung date na tinakda ni creditor. So, yun. Then, right to pay. So, saan ba dapat magbabayad? So, yun nga yung i-discuss ko kanina, no, kung saan, pero ito ay summary niya na. So, general rule nakalagay doon is stipulation of parties. So, both parties, kapag meron silang itinakdang oras at panahon, dapat masunod yun na kung saan sila magbabayad, no? Itinakdang oras at panahon. So, dapat nasusunod yun ayon sa general rule. If no stipulation, so ito yung summary na kayo ng sinasabi ko. Kapag sa general rule, stipulation of parties, ibig sabihin merong pinag-usapan both parties, si debtor at si creditor, may tinakda silang oras at panahon kung kailan sila magbabayad. Yun ang general rule. Kapag wala namang stipulation, if no stipulation, obligation to give a specific thing. So, yung sinasabi kanina, and then any other type of obligation. And then, whenever the thing was, the moment obligation was constituted. So, kapag obligation to give a specific thing, whenever the thing was, at that moment, obligation was constituted. So, pwedeng gawin, kapag ito ay specific thing, pwede niyang gawin kahit saan. Kapag walang itinakdang oras at panahon or lugar kung saan siya dapat magbayad, pwede siya magbayad kahit saan, kahit anong oras, kung saan, kumbaga hindi expected na magbayad siya or hindi expected na magkikita sila tapos bigla sila magkita, pwede siya magbayad ng utang niya. Halimbawa, utang yun, pwede siya magbayad ng utang niya. And then, so, if no stipulation pa din, any other type of obligation, domicile of the debtor. So, pwede niyang, any type of obligations na may sa katuparan yung obligation na yun, pwede siya niyang puntahan sa bahay, sa tirahan nito, tirahan ni debtor. Pwedeng puntahan ni debtor si creditor. So, pwede niya puntahan sa bahay or kung saan pwede sa office o nagtatrabaho may kung saan. So, may mga transactions tayo na ganun minsan. Puntahan mo ako sa ganito or sa mga best example siguro natin yung GNT, yung Lazada, ganun. So, kung saan walang itinakdang oras at panahon kung saan magkikita. So, pwedeng deliver sa bahay, pwedeng puntahan ng namili, no? Pwedeng puntahan ng namili yung GNT kung saan sila nakalugar, saan sila nag-stay, at pwede din namang ihatid yung deliver, no? So, yan. Pwedeng puntahan sa bahay. Halimbawa, may utang ka sa kanya, pwede mo siyang puntahan sa bahay niya para maisagatuparan mo yung obligasyon mo sa kanya or service mo. Pwede rin sabihin natin na yung sa mga manicure, pedicure, yung iba minsan nagpapapunta sa office para maisagawa yung obligasyon, tapos doon nila babayaran. So, pwede yan. No, kapag walang itinakdang panahon o walang itinakdang oras at panahon. So, yan. General rule, tandaan natin kung saan tayo pwedeng magbabayad. Kapag mayroong itinakdang oras at panahon, both parties, nag-usap sila na ganito, ganyan. So, dapat bayaran yun. And kapag wala naman, pwede mo naman kahit saan or kahit kailan mo lang babayaran. No? Kapag walang demand or walang itinakda na oras at panahon at lugar kung saan ka dapat magbabayad ng iyong utang. So, that's all. Thank you sa panonood, pakikinig, and sana ay meron kayong naunawaan, naintindihan sa aking presentation about sa law of obligations and contracts. Once again, thank you so much. I'm your presenter, Criselda A. Gregorio, third year from BSBA, major in marketing management. Thank you so much.